to the broken baker, where crimes are baked in every show. Mysteries rise and truth unfolding. Ready, set, it's time to go. We sing it's time to go. Whistling truth, battering news, mixing stories, solving the lies. In this kitchen, secrets are broken, with a spark in our eyes. In the broken baker's kitchen, where secrets crumble like sunrise. We'll sift through clues, defy the rules, with a spark in our eyes. The broken rise. Broken rise. Welcome to the broken baker. Get ready. Let's go.
I'm Jimmy. How y'all doing?
The most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a 15-minute break and both sides take a pregnant pause and think about the jury.
Good morning, good evening, good afternoon, wherever you are, what if anything you are. Welcome back to what can only be described as slice of heaven. Because Sarah Boone will now enter the courtroom. Sarah Boone, isn't she lovely? Isn't she beautiful? Isn't she hungover? Just on a Pruno diet. Hello, Tom. Well, pregnant pause means pause where you consider a little bit wasting the jurors' time as they did in that trial. It was in the Carly Gregg trial. Absolutely horrendous showing from both the prosecution and the defenders. Hope you're doing well, Tom. We always talk about, oh, let's do something together, and we never do it. No, it can't be just as bad as it was. That was Bangers on a Budget by Baker. Yeah, we have too much work. We don't have enough time to have fun together. But we'll have to. Well, I'm going hard on Sarah Boone, if you know what I mean. But we need to talk a bit. Talk about the civil suit and all of that stuff. I like it when you lie. But let's see all the good things. These are the motion hearings for having her interrogation thrown out. And did she get Mirandaized correctly? Yes, I was with the Supremes for a short while. We did Vegas with Elvis. It was a different time. Looney Booney going to get her makeup? Maybe. Oh, I can just let's skip ahead to something happens. Boom, ba-dum, boom, boom. Oh, they did put the pink handcuffs on her. She looks good in her. Yeah, as I said, someone asked about doing a release the rubber duckies. I said, no, someone in Canton should, if you have like a local pond or something, of course, get a permit, and then you buy a lot of rubber duckies off of Amazon, and people can come buy them, write their name and free can read on it, and release it, and then make sure to clean up after so there's no littering charges. You should do that. This is from yesterday. Just go to the spend money and check out dudes. She can check me out anytime she wants to. What's tomorrow night? Tomorrow night is Friday night. I'm probably sleeping tomorrow night. I have to go see my kids Saturday. Come on. Come on.
Today. Okay. Are there any housekeeping matters we need to address from the state side of the ledger?
Not on that motion.
Okay. Any housekeeping matters on your side of the ledger, sir, with regard to those motions to suppress?
No, sir, Judge. I believe we've got two detectives outside to testify, and we've also got the custodian of records from the.
Oh, Turtle Boy Trivia Night tomorrow night. Cool.
Is that a valid argument that you're still embarking on this afternoon based on what's in your second amended motion?
Yes.
Okay, so the sufficiency of the Miranda waiver is still at play.
I'm not sure I'm
Okay.
going to get
All right,
any
thank you, sir.
Auroras.
With regard to the other motions that were set for today, and I have reviewed the state's motion to strike, and I have reviewed all the case law authorities that y'all have provided to me as well. With regard to the defendant's motion for hair, cosmetics, civilian and clothing without restraints for trial, Mr. J, do you have any position with regard to the restraints at trial portion of that motion?
I believe a lot of the case has already been settled on that issue.
Okay, all right, we'll entertain argument when we get there. And I've also reviewed the state's request for protective order filed September 30, which is also set to be heard this afternoon. With that, we'll begin with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting to the authenticity of whatever it is he subpoenaed. I've been getting some of the documents, Orange County Sheriff's Office General Order 711. I don't see any need to belabor the custodian of records.
They show up in chat, but because I can see my free can read doggies, but it doesn't show up if I pull them up on like this. I started this yesterday and had to stop. The officer they bring up says 50,000 times before almost each sentence. Well, Sammy spills the tea. There's always something wrong with these stupid courtrooms. It's so rarely that we get a good one, and the audio is not the best either. But we have to hear if our girl gets her glam squad. Pay attention to her hairline. Something's off, but I can't figure it out. That she looks beautiful.
Sitting around. Was there something else? Did you direct the brand card? Yeah, if you look in the very back. If you look in the very back. Okay. You see the brand card, the last page, and the next to the last page. Yeah, there's no need to keep the custodian of records around for authenticity. We still have our objections.
Okay, all right. Can the custodian then be released by virtue of the state's stipulation as to that, those records?
Yes, can I tell what you do?
Yes. I also have reviewed the 2 hour and 6 minute.
Thank you, Vince, for the fist bumping super sticker. Hey, Jamie.
Yo,
What up, street girl?
what up, Holmes?
Oh, I don't know what you're sweeping, but you were about to say something.
Oh, that was my shirt. Sorry. I was trying to get the dog hair off my shirt. Nothing. How are you?
Well, we're just getting started, so you were at the right time.
Yep.
Investigation.
Let's
That's
do
pertinent
it.
to the motion to suppress.
To
The
it.
court has reviewed the entire video. With that, state you may proceed.
If we could, ask the court for Mark A for identification because of the ED
Hi, Tom. Good to see you. Hi, Ken.
platform camera.
Mm-hmm.
I have reviewed all of those in advance of today's hearing. Any objections? No objection. What was pre-marked as States A will be received into evidence without objection as States 1.
Yeah, I'm sorry Jess can't be here because she really wants to yell at him. But Sunday at 4 p.m. we changed the time. She will be here and we will be yelling about his motions. And we're not talking about the motion in the ocean.
Good afternoon, ma'am. Could you state your full name for the record and spell it for us?
Yes, it's Chelsea Castle, Chellsey. Last name is Koepsell.
Thank you. Counselor, you may inquire.
Thank you. Where do you work, ma'am?
The Orange County Sheriff's Office.
And what do you do for Sheriff Mina?
I am homicide.
How long have you been a homicide detective?
Over 6 years.
And what's your total experience with the Orange County Sheriff's Office in terms of years?
I am going on 12 years.
Any prior law enforcement experience prior to joining the Sheriff's Office? And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So for this case specifically, my team was on call that week for homicides. And so the deputy on the scene to notify the call center to notify the on-call homicide.
All right. And is it fair to say that you guys have 3 teams of 4?
Yes.
And each of the third weeks you will be on call?
Yes.
And then through some other random distribution, it's determined who of the 4 will be the lead?
Correct.
And it was your turn to investigate the death of Jorge Torres?
Yes.
And you were notified of this on February 24th of 2020 in the afternoon?
Yes.
About what time were you notified?
I would have to look at the catch sheet to recall directly, but I would assume within 30 minutes to an hour of deputies being on scene.
All right. And
Just going to put it in normal speed because she speaks a little fast. Make sure you bring up your birth certificate banking info as well while you're boomering, regardless of what I say. I'm not boomering right now. Just forgot it for 2 seconds.
do you go to the scene first or do you do anything else?
For this particular incident, I got my partner, Detective Sarah Lowen, and we headed out to the scene.
All right. And when you got to the scene, what did you do?
I met with,
She has the lip smack and the and she has the Valley Girl accent. I hate her.
the deputies there, and they kind of just briefed me on what was going on and what they responded to.
Did you do a walkthrough of the scene?
I did, yes.
And then was a search warrant drafted for the residence
Yes.
and later executed?
Correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes,
Do you see Sarah Boone in courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's over here on my left, and she's wearing blue.
May the record reflect she's identified the defendant.
Record will so reflect.
When did you first have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there. So once I spoke with deputies, I then went and introduced myself to her.
All right. And did you ask?
This is the lead detective. It was the Prego. Yeah, she's pretty but aggravating. Yeah, she's one of those. Again, right now, some guys looking at what's her name, Hadid, and thinking, "Oh my Lord Almighty, why am I with her?" And she's one of the most beautiful women on the planet. But imagine listening to that voice all day. Whew.
Ask her any questions at this time as you guys are standing outside of the residence?
Not
The state rested. Absolutely waste of time again today. Won't be going till Wednesday next week, where we will probably be on the Boone case. But I'll figure something out.
like detailed questions about like what happened because I've already was told by deputies what she had told them. So it's more just to like introduce myself and to let her know, you know, we're doing a search warrant.
Who says her interview is one of the worst in the world? That's a wonderful interview. Sarah Boone admits 10 times that she did it.
And the procedures of how we do things.
And when you respond to a scene, do you respond in plain clothes?
I do, yeah, like business professional.
Like what you're wearing?
Yes.
And when you made contact with her outside of her residence for this first contact, were you alone or was your partner Scott Lowen with you?
I believe Scott was with me.
And was he also similarly dressed in business casual?
Yes.
All right. And so how long was this initial interaction with Ms. Boone?
Not long. Maybe a couple minutes, 2 or 3 minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, like sitting out on their like front porch area.
Do you recall what you asked her in this initial contact?
I don't know who the behavior panel is, but the technique was wonderful. They just let her talk. I know that everyone is an expert and wants something done the correct way. But again, you have 2 hours of interview. You have her admitting it at least 10 times. I can't see what's wrong with that interview. And there might be a reason why Sarah is a little, but we'll get to that. No spoilers. But it wasn't intentional. Exactly, Irish. I don't, maybe they didn't follow the correct, I don't know, what's the name of that technique? Johnny's technique or whatever. But I find it good because they let her hang herself, and that's way better than them interviewing. We can go back and see that interview you saw this morning. I think that's worse than the one in Sarah's case. But again, there's also people claiming that Sarah's gonna walk, so what do I know? I'm a baker. Yes, she has gotten 3 lawyers. You have been on vacation for too long, Brandon. She has 3 lawyers now.
Do I recall what?
You asked her?
No.
Okay. So it was just a couple of minutes?
But again, the technique, yeah, it's all fine and dandy from a technical perspective. What a lot of people don't think about, because they are professionals talking about it, is who is going to decide this case. It's not a behavioral analyst or a cop, or it's 6, 12 normal people who will just sit and watch a drunk lady confess to a murder 10 times while yelling not intentionally. I think that works really well. I had never seen anyone watch that interview and not think, yep, she did it. So probably not by the book, textbook way, but again, it doesn't matter as long as the jury buys it. And I think they will buy this one.
That you were there with her?
Yeah.
Okay. And then what do you do after your first contact with her?
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else. And then once that was executed, we went in there further with CSIs. And then we talked to Brian Boone, which was the ex-husband. And then I believe we then sat Sarah into our unmarked vehicle and had a conversation with her.
Was that conversation in the unmarked vehicle recorded?
Yes, audio recorded.
And can you describe this unmarked vehicle for the court?
At the time, I was in an unmarked Pathfinder, so it was like gray in color. Didn't look like it didn't say like law enforcement or police or anything on the exterior. And there were lights like inside.
Where did everybody sit in this Pathfinder?
I sat in the driver's seat. Sarah sat in the front passenger seat, and Scott Lowen sat in the back seat.
Did you have any conversation with her about the facts of the case or your investigation that wasn't recorded inside the car?
No.
And that was all recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the start of this interview on that recording, did you not?
Correct.
Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for 911?
Yeah, I would say, yeah, because I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Miss Boone?
Just based off the situation and what was happening.
Okay. Is it in any way unusual to gather evidence before talking to the last person to see a decedent alive?
No.
At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was.
And when was that?
That same day.
I mean, when time-wise and in relation to talking to her?
Oh, well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSI's documented everything, photographs. And, so I don't think I really touched it until after I had talked to her about going through it.
All right. And ultimately, was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Yeah. Not go back in her house. But
Prior to that, had she been detained and requested not to leave the scene?
one more time?
Prior to your interview with her in the car, had she been asked or ordered to stay on the scene?
Not by me.
Okay. February 25th, was there a second interview conducted with you and Detective Lowen with Miss Boone?
Yes.
Prior to this interview, had her...
I hope so. It's a crappy... He should have been fired last season.
Phone been extracted by any member of the digital forensics team at the sheriff's office?
Yes, it had.
All right, and had you reviewed some of the evidence on there?
Yes.
Yes, they took her phone and then they said, we'll bring it back later, and she opened it up. You would say that's maybe a little coercion, but that's fine. They're allowed to do it. Then she used Brian's phone to call, and this detective said, well, I'm not feeling well, allegedly, and can you come in tomorrow and pick it up? And then they had the autopsy, they had the videos, and that's when they put her into the interrogation room, gave her her Miranda rights, which the defense claims they didn't. And then she admitted to doing it 10 times.
You had requested that Miss Boone come down to the sheriff's office rather than you returning to the scene?
Yes.
Can you explain that?
It's more of a controlled setting for law enforcement. We're able to audio and video record at the sheriff's office, and
Sheriff's office.
she had mentioned that she might not be staying at her apartment, and so I didn't want to go to the ex-husband's residence where her potential child was. So I just felt it was a more controlled setting at the sheriff's office.
All right. And when Miss Boone arrives at the sheriff's office, who goes down to greet her and where?
It was not me. But she would have gone in through, we have two entryways. So either on the record side or on the opposite side. And she would have had to go up to a window and request that she was there to meet with me. They would call me.
That's what I said on Sunday stream, because she does actually ask the question, but just in another way. Did you understand the rights I just read to you? And she said, yes. Do you want to talk? And then she keeps talking for an hour. But let's see if the judge ruled the same way.
I would tell them, yes, sign her in. And then if I'm not mistaken, I believe Scott, Detective Lowen, went down and got her.
All right, so you're describing two separate entrances that members of the public can come and go through?
Yes.
As opposed to separate entrances that might be in the back of your building where people are not free to come in and out of without a swipe card?
Yeah, the public doesn't have access.
All right. Now, in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Iris, behave. Question for the witness: have you ever straddled a bush? That's a sexual question. We don't ask those Irish. But thank you. And I actually misread it. I thought it said studied a bush, which is even more sexual. Hello, money. And MD.
Where are the CID or the investigation division's interview rooms?
They are located upstairs.
All right. And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with an employee of the sheriff's office.
And your testimony is it wasn't you?
I don't believe so, no.
Now tell us about these interview rooms.
We have 4 interview rooms that are audio and video recorded.
Okay. And they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the sheriff's office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't have other questions of this witness.
Thank you. Any
Come
cross-examination?
on, defense.
Yes.
Detective, I'm James Owens. I met you outside just a few minutes ago, and you know I represent Sarah Boone. Detective, have you had a chance to review any paperwork related to this case prior to this hearing?
I have looked at my investigative report, and I have looked at some policies, but they were from current.
Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Would it be fair to say that prior to you asking Sarah Boone to enter this unmarked vehicle for this interrogation with Detective Lowen, that you did a preliminary investigation as to whether or not this was potentially a homicide?
Yes.
And you would have viewed the scene inside the apartment?
Yes.
And you would have spoken to Deputy Rodriguez about what she knew about the situation?
Yes.
And you would speak to Deputy Rodriguez about what Sarah Boone had said had happened?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Potentially. I didn't listen to that interview. I don't know if we interviewed him outside or in my car.
Was he Mirandized?
According to the grand jury, what's it called? The big court you have. Supreme Court. Oh my God, I'm already fading. It doesn't mean anything. You can get around Miranda no matter what, almost what you do.
No.
Okay. So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or person of interest?
At some point, yes.
Tell us when that happened.
The next day.
Okay. So at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation. But due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then pending, once the autopsy was completed the next morning, was when...
I hate her speech pattern so much. The and the morning. Why, if anyone hears themselves talking like this, why don't you work on changing it? I used to talk like this, and I changed it. This is so annoying. Imagine being interviewed by her. So, you were at the scene, and you saw the murder?
I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized, and she went to jail later that evening.
While you were there on scene, I know at some point you saw her phone on the kitchen counter.
I did.
All right.
Or maybe on the microwave. It was somewhere in the kitchen.
All right. And at some point you went to Sarah Boone and you asked her for the password to open the phone.
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Sarah's just sitting there daydreaming about having a cocktail or being on Dancing with the Stars when she gets out in a few weeks. You know it. Well, she's just dreaming about going to the mall, spending money, and looking at dudes. And one of those
Checking
dudes
out dudes.
checking out dudes. And one of those dudes she's going to be checking out will be me. I will move, well, not move. I will fly to Florida just so she can check me out because...
Sir.
Jamie, the heart wants what the heart wants.
Well, sometimes you need to just say no.
Yeah. But imagine those alky legs straddling you instead of a bush.
Yeah, I can, and it's my worst nightmare. But you know what? I support you. You do you.
What do you think about her accent, Jamie? You are kind of a valley girl yourself.
Me? No. I think the lawyer is more annoying than she is, to be honest with you.
Be that bush.
No. No one ever be that bush.
My stream deck isn't working, but there's a lot of giggities we're missing today.
Okay, so not before? You didn't ask her before you asked her to sign the consent form? Sarah, give me the password to your phone.
Not that I recall, but why would I would normally have her sign the consent form first for her consent.
Was her code
to the phone
0,
and then
0,
gather the passcode or whatever.
0?
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to?
I didn't go to law school. Let me figure this one out. She saw the phone on the kitchen counter and she said, "Hey, Sarah, we want to have your phone. Can you sign a consent form?" That's how it came about, that she signed a consent form. And then when she signed it, said, "Could you unlock it for us, please?" And Sarah said, "Yeah." Just because you have an idiot for a client, it doesn't mean you are asking good questions. I'm at the belief Sarah could do better without him.
Searching the phone.
She called 911. So I told her that we needed to corroborate her story as to what occurred.
Okay.
And so to do that, I wanted to go through her phone.
All right, do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Was it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, did your testimony is you asked her for her password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital.
I want the million and love.
All right. You're talking about the digital investigator, and they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh yeah, she didn't come until later.
Later.
I believe around 7 p.m.
Okay.
That's when in the CAD sheet it says she arrived.
And you know there were two videos on Sarah's phone.
After I spoke to Sarah.
I'm sorry?
After I spoke to Sarah?
All right. So what I'm gathering from what you just said is
I don't think so.
at some point you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
Where we completed an interview? Yes, sir.
And your testimony is that you did not view the videos that were found on her phone. And I'm referring to the 2-minute video of George in the suitcase. And then some time went by, and I think there was about a 22-second video of George in the suitcase that Sarah took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those 2 videos.
That's correct, sir. I did not go through her phone until digital forensics came out and then went into her phone. And then she brought me over to her van to tell me about the videos and what she found.
All right. So your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived.
Correct.
Okay. Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah before y'all got in the vehicle?
Of course.
And did you tell Sarah that y'all...
Feast on it. I built it myself. Welcome back, Jenny. Oh, yeah, they would have fun together. The other trial is on hiatus till Wednesday. The state rested, and the reason why the judge got more and more angry was she had another case starting this afternoon. So the case will pick up again on Wednesday, but we have to see when Sarah starts up. But I will find some way to cover what happens in it.
wanted to talk to her, and this was routine?
This is the officer who interviewed Sarah Boone.
Protocol.
Yeah, that I wanted to have a conversation with her, and once I had walked through the house and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically said that, sir. This was 2020.
Okay. If she recalled that, would you dispute it?
Objection, improper question. Sustained.
Your testimony is you don't remember saying that.
I don't remember specifically saying what. One more time. What is it that she claimed that I said?
Routine protocol.
I would not interview her not in my unmarked car. So my routine protocol, sure, I would do that.
I would not interview her not in my unmarked car. That's a double negative. Does that mean she would interview her in her unmarked car?
Don't start this. Confused me already.
She would not interview her not in her unmarked car. So she would only interview her in her unmarked car. Yes, the audio is really unbalanced, and I can't do anything. I was right, Jamie. You're wrong again. Well, it does mean, as Jess said, they have a camera in there. Yeah, she wouldn't interview her in the open, but they do talk to her out in the open. Yeah, please, Jamie, wake up. Hey, Chrissy, been a hot minute. And two
Hi,
cold
Chrissy.
interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car?
Yeah.
Standing?
Yes.
No.
Well, you would have to tell her something.
I said, yes, we're going to go have a conversation in my car now.
Okay. And did she have any questions that you recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat when we were going to talk in the vehicle, yes.
Okay. And you don't recall whether or not you said this is routine protocol to come into the car and talk to me?
Those words specifically, no.
Okay.
But I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
All right. Now, once inside the squad car, you were there with the other detective, Detective Lowen. Okay. And you read her the Miranda rights card, correct?
Yes, from my card, yes.
Do you agree that you didn't ask her the last question, number 9?
Objection, relevance.
Response.
Judge, we're here on a hearing on the issue about the interrogation.
But of the case law that you provided to me, none of it stands for the proposition. Miranda identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card that is in the motion upon information and belief. This is what it says. So how is it relevant for the purposes of today?
Well, it's relevant because this is the policy of her department.
But
the policy isn't the law. I can have a policy on my channel that Jamie can't speak because I run this channel. But I can make all kinds of policies for the street outside of my house and say, Jamie can't speak out here. But that would be superseded by the law, which gives Jamie the right to speak. And she wouldn't follow the law anyway because she's breaking the law.
A rebel.
It's such a stupid thing because you can have all the you can have a policy that you will only call every inmate in prison John. And if you call one of them Adam, he's not released from prison. It's just a stupid policy. It doesn't bear any weight in a courtroom. Is he a lawyer? He doesn't understand the difference between a corporate policy at the police
Baker.
station.
Listen, he has a website with a picture of him and his wife. Of
And
course,
more
he's a
than
lawyer.
100 cases.
To jury.
How much do
So-
bears weigh? I think roughly 400 kilos. Maybe it's 400 pounds. No. And again, I'm a stupid baker, and I can figure that one out because it's the same. You can make a policy stating that every cop must wear a BLM sticker on their shirt or they'll be fired. But they can take it off and say, well, we have that Supreme Court and Constitution thing saying I have the freedom of speech. So if I don't want to say this, I can also not say it. It's stupid. Are we wasting time on this idiot?
Judge,
what is the policy? But now we're getting away from the card to now the policy. There's nothing about the policy right now. The question is about what the card says.
Okay. The card is the policy, and the policy is the policy. They're intertwined. They refer to each other.
But they're not the law.
Our argument is that she did not waive her rights.
But
Remain
that's
silent.
She waived her rights implicit by keeping talking. The Supreme Court have already ruled on that. You can forfeit your Fifth Amendment right by keep yapping. You don't have to say, I'm not talking anymore. And then you say, I totally murdered that guy. Oh my God. Pew, 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 straight in the face. That's so crazy. Blood, brains, everywhere. It was like a piñata full of candy, just with brains. Oh, by the way, I said I have my Fifth Amendment right, so you can't use any of that against me.
That's a different issue than what is on the card.
I understand, but it's a coercive question about her not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the sheriff's department. She elected not to answer a question that the policy says read verbatim from the card. Why did she not want it? Our position is it was an attempt by the...
Yes, the four pins in Miranda was read. She didn't read verbatim what the card says, but she says, do you understand those rights as I just written? Do you understand what I just read to you? And she says, yes. So again, she answered in the affirmative. She was aware of the 4 pins under Miranda.
This detective to coerce Sarah Boone into talking.
That's not coercion.
On February 24th or on February 25th?
On February 25th. This interrogation ties into that one. She used the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm sure, I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement.
Well,
but what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. If she understood her rights and then she consciously and freely waived her rights. She was not asked that question. She was not.
She doesn't need to consciously and freely waive her rights in verbatim. She can do it by her actions. You must know this.
Asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider as to whether or not that statement should be suppressed.
Any other response?
Judge, just like it's irrelevant what the sheriff's office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida, or the United States and federal case law and the state case law interpreting the United States Constitution, the policy is irrelevant, and the officer's subjective intent is completely irrelevant in a motion to suppress, just like it would be in a traffic stop under Wren versus United States. What matters is objectively what was spoken to the defendant, and I would ask that we honor the local administrative order and call people by their surnames and not their first names. What matters.
The 5 pins. Okay, sorry, I said 4. 5. You have the right to remain silent. She's read that. She says, yes. Anything you say can and will be used against you in a court of law. She said, yes. You have the right to attorney. And I think 3 and 5 is merged together. But she says, yes. If you cannot afford an attorney, one will provide it. Yes. And if you decide to answer questions now without an attorney present, you will still have the right to stop answering at any time and we'll talk with an attorney. The only thing she doesn't get asked is, do you understand the rights I had just read to you? With these rights in mind, do you wish to speak to me? But she's asked in a roundabout way. I snuck a roundabout in, Jamie.
Is that the defendant was read what the case law requires. Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both the parties.
Last bite at the apple.
I'm sorry?
Last bite at the apple. Last bite at the apple. Any other argument?
Judge, we're talking about the totality of the circumstances, whether it was coerced or not. You can take any technique or a non-technique, something that you use or don't use to establish whether or not it was coerced or not. The fact that she didn't read, do you understand the rights? Do you understand these rights, which is the form, the Miranda warning form? Do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you. And you're referring about surname. What do you mean by that? You mean,
That means last name.
okay, what did I say?
These
What?
lawyers don't like each other.
Nah.
This was shut up, bitch.
And do you wish to talk to us at this time?
Objections overruled.
Thank you. And you're referring about surname. What do you mean by that? You mean,
That means last name.
okay, what did I say?
I think he knows what surname is. He's not that stupid.
This detective?
Keep calling the defendant by her first name.
All right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone, that's fine.
Okay.
You may proceed.
Have you had a chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office? Do you agree that you did not
Spoilers,
read
please.
the 9 questions to her in your squad car?
All 9 questions?
Correct.
No, I didn't.
Yes, they do ask her if she understands the rights, and she says yes. And again, by her action, she waives her right to remain silent. Because, again, you can't... I can't tell Jamie, I don't want to talk. I plead the fifth. And then I tell Jamie, oh my God, Jamie, yesterday, I was so hammered. I was out driving. I hit 5 mailboxes and 2 old ladies. Boo! Blue hair and legs everywhere.
Jesus Christ.
I don't want to
Baker.
talk about what happened yesterday, Jamie. I can't just, you can't opt in and out of it. Either you shut up or you waive your rights by your actions.
Not read all 9 questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my Miranda card.
I'm sorry?
It's not on my Miranda card that I continue.
What do you mean by that? It was the card that you read, it was not on the card?
Number 9, no, not on my card. We have multiple Miranda cards at the sheriff's office, but yes, that is the in reference to the policy. Yes, that is the policy.
Well, somebody dropped the ball somewhere. Did you fail to get,
Proper question.
Sustained.
did you fail to get the most updated card, or how did that happen, that the 9th question was not on your Miranda rights card?
I've had that card since I started being a detective in sex crimes in 2013.
Have you become aware, as it relates to filing this motion,
I've become more aware, yes, that there is that card.
have you gone and gotten the updated card?
Objection, relevance.
Sustained.
Claire, Bill, it's the reason they want this Miranda thing to stick is so her police interrogation can't be played for the jury. Because in the police interrogation video, she admits to doing it. She admits that they were having a great day. She admits that nothing was wrong. There was no reason for anything to happen. She has now claimed battered spouse and self-defense. So if she can get that one out, she can then claim, well, he was treating me like a piñata all day, so I had to defend myself. It would still be a really bad argument because the second he's locked in the suitcase, the imminent threat to her life disappears. So she can call 911, she can leave the house. Leaving him in the suitcase to die would still be at least a manslaughter. But if you can get the police interview out where she claims 10 times, I did it not intentionally. I left 2 fingers of, we had a wonderful day. If you can get that stupid little mistake she made out of here, then you can change your explanation of what happened that day and say, he was treating me like a piñata. and he really liked that toffee roll that was in the middle. So he was going at me with a stick. But if she does,
no, go ahead.
if she does that now, they can impeach her with that video and say, "But that's not what you told the police earlier."
Would that mean that they could easily get the other video thrown out too? Because if they got the interrogation thrown out because she wasn't read her rights, then do they not have the right to go into her phone either? Is that? I'm just curious. That was just a general question.
They would have the right to go into her phone because she signed a waiver for the phone.
Oh, she did.
But they would also have the officer they could call in with the body cam video, because that's not an interrogation. That's just what she saw at the scene. And they could impeach her with that as well, because she also tells her it was a good day. But again, this is just a ploy to get all of this evidence out so she can change her testimony.
Gotcha.
Well, she wasn't detained at the moment. She voluntarily.
When y'all took her phone, Detective, did you tell Sarah Boone that you would be returning to her apartment the following afternoon to give her phone back? You did not tell her that?
No, I listened to all my interviews, everything that's been audio recorded. No, I did not tell her that. We had plans to meet at the sheriff's office.
Or tell me what you understood the conversation was as it relates to her getting her phone back.
That they should meet at police officers. She just said it.
I'm sure she asked when she'd be getting her phone back, and I didn't give her a detailed timeline. I said that I don't even know if I told her that I decided to write a search warrant on it, because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, and so I took it, and I wrote a search warrant for it.
Okay. But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
Specifically returning her phone, no.
Okay. Do you recall her calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you have documentation of the phone call?
I have her testimony.
Oh, okay. Well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
You said that y'all had some discussions about Sarah Boone coming to the station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And did you relate to Sarah Boone that she needed to come to the sheriff's department the next day to retrieve her phone?
She went to Brian's house to stay that night and used Brian's phone to call the police to ask for the phone back. Brian is her ex-husband, the guy who said, yeah, they go at each other a lot. I called her because I wanted to make sure she picked up our kid at school, because she's not really good at that. He's also the guy that they want to come in and testify that Jorge was a bad guy, and the state will then ask, did she ever swing at you? Yes, she did.
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you?
Something along those lines. Yeah.
Okay. And when was it that you actually saw the two videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
I've already answered, but yes, it was after the interview.
All right, and was it while you were on scene?
Correct.
Okay. And did you attempt to talk to Sarah again about that at that time? Okay.
I've watched bits and pieces of this. The two sets of lawyers don't like each other, and I don't think the judge is impressed with Mr. Owens. This can turn really bad.
And so did you let your detective partner know about the videos on Sarah's phone?
Objection, relevance.
Overruled.
Did you let your partner know about that evidence? Okay. And did y'all discuss that issue?
Objection, relevance, work product.
Sustained.
At some point, y'all had to, were y'all working together, or were you making all the calls, or were y'all making joint decisions?
Objection, relevance, work product.
Sustained.
Ma'am?
There's no pending question at this time, ma'am.
At some point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection, relevance.
Overruled.
Yes, at some point I did.
Did you make that decision by yourself, or was it collectively made by others with the department?
Objection, relevance.
Sustained. You don't need to answer anything.
Detective, at what point did y'all that next day, I think you had her coming in the afternoon?
I believe it was around 3 p.m.
Did y'all work on trying to get the search warrant for the phone?
I got the search warrant for the phone, and I believe I submitted it that evening. I would have to look at it though.
Okay. Do you know what time the search warrant came back signed by the judge?
It's documented in my investigator report, but I don't know.
Okay. And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
Yes.
Okay. And would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
Yes, I attended an autopsy in the morning. That's why I asked her to come in.
All right.
Yeah, his questionable choice was leaving this wonderful woman.
Oh my God, stop
I think him leaving Sarah was what drove her to this. I blame Brian.
What time was the autopsy that morning?
It starts at 8, but I didn't probably get till 10. It takes quite a few hours.
Okay. And were you there alone with the medical examiner, or were there anybody else there?
It has nothing to do with this. He is just, as someone said, playing bartender, grasping at straws. Never heard that one before. I'm going to steal that from now on.
I don't recall if Detective Lowe was with me or not, but
Yeah, lucky
yes,
guy.
of course there's doctors there.
Okay. And so in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video, the 2 videos from her phone the day before the autopsy?
Objection, relevance. Custody is not disputed on the February 25th statement.
How's this relevant? If the issue is knowing an intelligent waiver, the sufficiency of Miranda, and coercion, what does the formulation of probable cause have anything to do with anything?
Well, I wanted to bring out the fact that they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her. So that if she, A, either didn't come in, they were going to go arrest her that day, or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway. That they had already made a decision that she was the prime suspect. They had probable cause.
What does that have to do with any of the 3 issues that are?
You are asking to have it thrown out because of Miranda problems. And now it's because they already knew she did it. Sarah, don't listen to me. This is not legal advice. You can still throw this guy out.
Raised in the motions.
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
I think my response.
That's my understanding. The state's not disputing that there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided prior to that.
Judge, it was provided the day before, and she's just testified she was free to leave at any time.
Okay.
So Miranda was given on 2 separate occasions. She wasn't in custodial interrogation. Detective, am I right? The day.
Well, hang on. Before we ask any questions, let's drill with the evidentiary objection first.
Okay.
The objection sustained.
Okay.
You may proceed.
All right. Ma'am, you would agree that when Sarah Boone arrived that afternoon for the interrogation, she was not free to leave?
No, Emma, this is from yesterday. Yesterday we were covering the meth trial. So That ended early today, so we could just sneak this one in. Just like Sarah Boone could sneak Jorge into a suitcase.
Oh my God.
She was not.
What?
Excuse me?
She was not going to be free to leave.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway. And that was based on your investigation that you had the night before at the scene. It was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the 2 videotapes that you saw from Sarah's phone.
Objection, relevance as to what probable cause basis.
Sustained.
You had all that information.
Glow, I'm thinking if he can at least get a nice stab at this, he can be the next court TV talking head or the next Emily D. Baker. Because he didn't testify. He said that he had seen her advertisement on YouTube's, and we know that he at least knows EDB, lawyer, Know Your Lawyer. Come on now, Peter Trakers is from Florida. You should know his name, lawyer. You know, Legal Bites, who I don't think have covered much of this trial. So I think his dream is to become this. And let me just tell you, sometimes it's fun. A lot of times you just have to sit and listen to a lot of people's stupid life choices. But luckily, Kathy is saying, I'm going to make a point to catch more of these lives. I have found my YouTube tried. Great host, and the chat is intelligent, funny, and friendly. Zach hasn't been here today, so that's why chat seems okay. But thank you so much, Kathy. And yes, Jamie is both wonderful and intelligent. And chat is the bestest. I know everyone says it, but I'm the only one not lying. It's your chat too, Jamie. Come on, talk them up a little bit.
I love everybody here. Are you kidding me? I have a good old time.
Yes, we do. We do have that.
Before you began your interrogation on the 25th of Sarah Boone.
I had all what information?
All the information that I just related to you.
And Vince Clotho, I think you've been a member before, but you go on the board as well.
Before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the 25th.
Objection, relevance.
Overruled.
Yes.
Okay. And would it be fair to say that you wanted to get statements from her relating to the injuries to George Torres from the autopsy?
Objection, relevance.
Overruled.
Yes, I wanted to have a follow-up conversation in reference to what she told me the night before and in reference to the injuries that she failed to mention.
And you also wanted to question her about the 2 videotapes that you had found on the phone?
Objection, relevance.
Overruled.
Yes,
Yes, I do
Okay.
want to show her the videos.
And you agree, in your opinion, the 2 videos and the autopsy were inconsistent with the story she had given you in the squad car the day before?
Objection, relevance.
Overruled.
The videos.
I don't think his legal age is there today.
Repeat your question one more time.
Today.
You would agree that the autopsy results and the videos that were extracted or taken from her phone recording George, those 2 pieces of evidence.
Irish, are you here? Why?
Why?
Because I want to know if it's normal that Jorge becomes George. Because to me it sounds so weird. He's the only one calling him Jorge, George. So I was just thinking maybe it's kind of like that William Bill thing, that you called Williams for Bill, or the other way around. No, Bill. Yeah. Yeah, I know, but that's the same saying. Geo is George. But why not keep? Isn't Florida very mixed? There's a lot of Hispanics, so wouldn't everyone know that his name is Jorge? I don't speak Spanish, and I know his name is Jorge.
I thought,
Do you pronounce it George?
I don't know, to be honest with you. Now everybody's got me confused.
Yes, I know it's synonymous, but it's like saying Jesus and Jesus. If you meet a guy from Mexico named Jesus, you wouldn't call him Jesus. You would call him Jesus. Finkel is Einhorn, and Einhorn is Finkel. I don't know. Yeah, I know it's interchangeable, but again, and I know Sarah called him George, but I think because we know Sarah didn't like his family, so I think she might have been a little bit of the R word. So that's why she wanted to Americanize his name, but everyone else calls him Jorge. I don't know.
Yeah, I'm with Boosh. Names don't mean crap around here.
Did he himself pronounce it George? Then it's something different because the detective calls him Jorge. I don't know.
From your investigation,
let's agree to disagree. I heard it both ways.
Were inconsistent with the statement that she had given the day before in your squad car.
Did he give you 30 pieces of silver? Then look out. Or did he tell you about a rooster crowing 3 times? Jamie will, next Sunday in Jamie's budget Bible school, she will tell you the story about Judas. It's a horrific story. Don't. So that's why if you're ever at a dinner with a guy named Jesus and he gives you 30 pieces of silver, say no thank you. I'll take the tab today. But Jamie will talk about St. Pietro and the 3 crowings of the rooster on Bible on a Budget, Sunday at noon.
Over.
Yes. It should have been your show.
I believe that's
I do trial coverage. You do all the other things.
ultimately the reason you arrested her, because of her inconsistencies.
Objection. Irrelevant.
Sustained.
Now, you said you've had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
The Orange County Sheriff's Office.
The Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video with the audio.
Okay. Have you had a chance to look at my motion where the question and answers are typed out?
Okay. Thank you, Special K.
At least the first minute or so.
No, I have not looked at your motion.
Okay. Do you recall you saying to her, I'm going to have you sit in the green chair?
Objection. Best evidence is the recording.
He's right.
Okay.
Objection sustained.
Okay. Do you agree, prior to reading Miranda, that you mentioned to her that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that, referring to the autopsy?
Objection. Best evidence.
Sustained.
Do you recall?
I say Jorge.
Making some comments to her prior to reading her the rights?
Objection. Best evidence.
Overruled.
Yes.
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Objection. Relevance.
Overruled.
One more time.
In Danish, that would be Jorge, if you read it verbatim.
I assume that's not the first time you've read Miranda to a suspect.
Objection, proper question.
Sustained.
Let me go back to the first question then.
Thank you, Brian. Then I
Is
will.
it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled as relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Objection, proper.
Sustained.
How long have you been with the Sheriff's Department?
Holly and Jamie will do the show Sundays.
Since 2013,
How long have you been a homicide detective?
over 6 years.
Okay.
And it's homicide. I don't know why he says homicide.
Have you ever been trained or told to ask or not to ask any statements or any questions prior to reading Miranda relating to them talking to you?
Objection, relevance.
Sustained.
What?
Can you tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and I wish to have a conversation with her.
All right. Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection, relevance.
Overruled.
I did not ask her question number 9.
Okay. Do they have a Miranda cards form in the interrogation room?
Yeah.
So you would have had that on your person?
The good thing is we're watching it later, so we can speed it up when this weirdo. I really don't like him. I
I'm a
hope-
huge fan of her.
I hope she has the other one is better than this. But again, the medical examiner expert was found with body parts in his storage unit. It doesn't seem like it's the A team. Bam, ba-dam, bam, 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 bam. Could be cool.
See if you recognize that document.
Yes, this is our waivers and affidavits.
Is that filled out of waivers and affidavits?
It's filled out by me, but there's something highlighted that I did not do.
And was that form filled out as it relates to Sarah?
Why does she constantly look like her husband just told her, honey, we are going to go to Idaho this summer, spend our vacation on the farm. You didn't want to go to a poolside and drink wine, did you? She looks really.
I love that that's what you think is the worst case scenario.
I couldn't come up with any other states. I was almost about to get my map, but we could say Wisconsin, Jamie. Wisconsin. We're going tubing in Wisconsin. We know how that ends. I would make this face if you said, "Hey, Baker, want to go tubing in Wisconsin?"
I can't wait. Like one bad event ruin river tubing. It's so much fun.
Drinking on the river should be fun, less stabby.
Yes.
We're talking
Very
about
much
just this top, right? Okay, I'm sorry. Does it what?
Does that form, is it filled out as it relates to Sarah Boone?
In case, yes.
Is that her signature or what?
Yes.
What state can I this?
Yes.
Is that your signature?
Yes.
And is that the consent for the phone?
The consent to search. Yes.
On that form, is there also the login?
I don't know.
Yes.
It's probably somebody everywhere.
That is a form that's standardized by the sheriff's department?
Yes.
Well, West Virginia is a good
Did
one.
not read a Miranda from those rights?
From this piece of paper,
Yes.
that's audio and video recorded. That no.
Okay, you would agree that there's no questions on that form?
Yes.
It can't be Ohio because that's Jamie's.
Same objection to the relevance. As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave a statement to the detectives. And again, under the case law, there's no requirement for this question 9. Under any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the Fifth Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness of her waiver of her Miranda rights.
Response.
Judge, obviously we disagree.
Then where's the case that supports that?
Because
Because as I addressed previously, I read all the authorities. I mean, State versus Owens, State v. Thomas, Powell from the United States Supreme Court, which reversed the Florida Supreme Court decision. I'll talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that,
It's
Judge.
the right to remain silent, the right to an attorney, before and after questioning. If you can't afford one will be provided to you. Everything you say can and will be used against you. Those are the things that Miranda highlights. That Miranda opinion itself says that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including but not limited?
I can't say enough bad things about Massachusetts, but it's too easy. It's low-hanging fruits.
To Miranda itself and Powell. And then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state. Identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
Okay, I want to finish my argument.
Okay.
She has a duty.
Did you just
read the
hush the
rights.
judge? Oh, I'm thinking this is going over just as good as a fart in church.
That's not one of the requirements.
She has a duty to read the rights.
But they were.
Okay, I want to finish my argument.
Okay.
She has a duty to read the rights. She has an obligation to ensure that Sarah Boone understands her rights by asking that question. Do you understand the rights I've just read? And then there must be a waiver. Yes.
No. You waive your rights by your actions. MG, am I totally wrong? Your action is enough to waive your rights. By answering question number 1, you have waived your rights. Of course, not the question, did you understand what I said? But did you do it? Tell us what happens. You waive your right by your actions. You don't have to say, I waive my rights. Yeah, it's an implicit waiver. How long must you practice before you know this? Arizona, go on vacation, leave on probation. But it's too hot. I couldn't go there. But why do you go on probation in Arizona? There's nothing to do there, is there?
Maybe people get so hot in Arizona that they just commit all the crimes because they're just delirious.
By choosing to answer questions, you are waiving your rights. Yeah. It's how he has 100 cases he has taken to trial. How can a stupid baker in Denmark know more than he can? me thinks she's not genuine.
I understand the rights, and I agree to speak to you now.
No.
And then there must be a waiver. Yes, I understand the rights, and I agree to speak to you now.
No.
So for that to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with the detective is she reads the rights, do you understand the rights, and then she goes right into questioning. She goes right into questioning without saying, do you agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement, and whether that waiver was.
But it's a dry heat, so it's fine. So it's fire. Yeah, it's fire.
Yeah, you say that.
Yeah, it's so stupid because the only thing they must ask is, did you understand your rights as I just read them to you? And there's no, do you want to continue question. I think Jess is sitting in her office yelling right now.
So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the sheriff's department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify.
Yes, she could, after when they bring out the video, she can say, I don't want to talk to you anymore. I want my lawyer. And they could say, well, why don't you just answer that? And she said, I want my lawyer and I invoke my Fifth Amendment rights. At any point, she could have done that. So, again, he's not even grasping for straws now. He's just, I don't know.
About what she perceived at the time.
At the wall.
That the detective failed to read that question and how it ties into the case. I understand that all they have to read is those four. But I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider. I know it was an honest mistake. She had an old card. But still, I feel like it should be considered in your decision.
Anything else, Mr. J?
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection as relevance by virtue of the decisions in Thomas 351, 7th, 3rd, 197, and Owens 41, 7th, 3rd, 352. There's, it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
Do you agree, Detective, that after you read her those Miranda rights,
come on. What happened? What happened?
She didn't want
that Miranda in the squad was different from the situation? I
don't know what happened. It just went away.
You would agree the situation on the 25th, when you were reading her Miranda and about to question her, was different from the situation the day before when you read her Miranda in the squad car?
Yes, I had more evidence.
That was without the autopsy. That was without the two videos from her phone.
Thank you, MP. Thank you. I was thinking, what?
Yeah, at the time of the interview. Yes.
Yeah. And in the squad car, she was free to leave.
I mean, I didn't tell her she was free to leave, but I mean.
Thank you, Mac in Florida. It's been a pleasure having you here as well.
I mean, if she didn't want to talk to me, she
2
didn't want to
months.
talk to me.
Okay.
I actually didn't think he would be this bad.
That's all the questions I have at this time.
you.
He's
Can
really
you
bad.
redirect?
No, thank you.
All right. Can this witness be released?
I'd like her to stay.
All right. Subject to recall. Thank you. State, you may call your next witness.
No additional witnesses or evidence on this issue, Judge.
Okay. All right.
Sarah's Laura was a straight A student. Yes, she used to have a straight A student lawyer, but now she has this guy. And thank you for 3 months.
Anything from your side of the ledger, sir?
Judge, I would like, you stipulated to the introduction.
No, I don't object to the authenticity.
All right, Judge, I would like to introduce.
Yeah, and again, no matter what Sarah believed, it is what any reasonable person would believe in that situation. So even if Sarah thought something, it doesn't matter. Well, I've seen a lot of bad YouTubers, so it works for some of them.
Just that one.
Yeah, she had some questions, and she needed her phone back. Yes, she was on Nickelodeon and said Jamie's favorite line ever.
What is it that's been marked as defense exhibit?
Going to the mall, spending money, looking for dudes.
Checking out dudes.
Checking out dudes. No, MG, you are one of the good ones.
Any objection?
Same objection. It's irrelevant.
Just about.
Is it the form as of now, or is it the form as of 2020 when the...
Let me see your beautiful face.
Okay.
Turn around.
Can I see it for a moment, please?
Every now
Thank you.
and then I get a little bit low.
Any additional argument with regard to the state's relevance objection? No, I'm sorry, Mr. J, I wasn't specific enough. Mr. Owens, to you. Any additional argument? All right, I'm going to sustain the relevancy objection for the same reasons the court articulated previously.
Sarah, look at me now. Total eclipse of my heart. What?
And Mr. Owens, you had one additional exhibit as well?
This is a composite exhibit, Judge. It's the policy of the Sheriff's Department.
Jealousy is an ugly color on you, Jedi. Yes. She's overconfident and thought she could talk.
Do you know what page specifically those policies are on?
Page 14 of
You're not allowed to despise Boone. She's a lovely woman who is wrongfully indicted. And I've seen this so many times in courtrooms. They think I'm so smart, I can talk my way out of it. And it just goes further and further down the drain. It's so funny to see because when the prosecutor then asks them a question, they say, hey, but this is an inconsistent statement. They'll just go deeper and deeper. Woohoo, Hoylon. Finally, how much are they down? And thank you for 11 months, Vilu. My Finland crew. We haven't seen Medina
11
today.
months. Wow.
Yeah,
22.
I could have a marriage in those 11 months.
Mm-hmm.
And I'll give you
Yeah, that.
2 more pages.
Is it beginning of paragraph 4, waiver of constitutional rights?
Yes.
I would voluntarily crawl into the suitcase. Agree. She's as innocent as Jodi Arias.
Oh my God.
And a little bit more, a little bit hotter.
Okay, I've read pages 14 and 15.
Well, we just call it reading your rights. We don't name it after a Spanish lady. It's just your rights.
All right, Judge, and then you go to 13 of 28.
13?
13, well, it's the next,
Oh, there's two different sets. It's a
Split up.
composite. My apologies.
it's split up.
Got it.
13 of 28 at the bottom, P.
Mhm.
And then it goes on to the next page, 14 of 28. Specifically 2A on 14.
In Denmark, it's if you are indicted or arrested, they must tell you on what grounds you are indicted or arrested. They must tell you you have the right to shut up, and they must tell you you have the right for an attorney, or else they can't use it against you. We must always give our name, address, and date of birth. If the police ask, so we can't Fifth Amendment us out of that one. But the rest of it, we can just say, I don't want to talk to you. So, and they can only get your birthday, not your social security number or anything. So, and remember, in Denmark, if we want a defense lawyer, the state will pay for them. And we can get anyone if we know one of the famous ones. If they if I say I want John Johnson, they will try and get me him if he has room in his calendar for it, and the state will still pay, even though I get if I it would be the same saying I want Alan Jackson, and then the state would try and get me Alan Jackson, no matter that I can't pay for him. That's my right in Denmark. That get the lawyer I want, not just be someone in a pool that they'll give to me. If the other guy can't do it, of course he will then find someone else. But we don't have a public defender system. It's regular defense lawyers who do the job, and the state pays for them. And then you'll have to pay for it. It was a Spanish man. I don't see gender, Dave. I'm very woke. Miranda is a Fanta-like soda.
Anything else?
No other argument, Judge, other than what we've talked about.
Anything further?
Same arguments.
Okay. All right. I'm going to overrule the objection as to relevance as to what was pre-marked as composite C. And that'll be
I probably wouldn't use that because that's the new word for the KGB, I think.
received into evidence. Over objection is states 1. I'm sorry, defense is 1.
Trouble writing that a lot. If I can't afford an attorney, as I just stated, I'll say I want John Johnson, and they'll try to get him for me. The state will pay for him for the time he spent on my case, and I will just owe the state, and they'll withhold it in my money or whatever. But I can name the biggest, fanciest lawyer in Denmark, and they will try and get him to me.
Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Woohoo!
Ms. Boone can approach the podium.
Woohoo!
She was previous this morning.
Oh,
My love, Sarah Boone.
boy. Hey,
Would y'all be here?
Yes, sir.
And just to prove I'm
Paul?
right again, and all of you are wrong, Miranda is a soda. It's delicious and
Just-
flavorful orange taste.
just like your body washes palm olive dishwashing soap.
That's just racist. Why is she taking?
Hang on, the deputy's got to move her.
Look at that. Oh.
Have you already been sworn? Counselor, you may proceed.
Let's
Now,
go.
would you please state your full name? You're going to have to speak up or move the mic.
Sarah Boone.
Yes.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase.
I can't remember if Fanta was the substitute they made for the Germans after or during. I'm not sure.
You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What
Fanta was introduced in 1941, so no, wasn't around before.
state did you have at that time?
I was very confused. It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking.
The monumental amount of people that was there.
Yeah.
Sarah,
She's trying to use big words.
your sweet voice is like angels playing their harps, but don't ruin it by saying stupid things.
In my home, I was worried about my dogs. I was worried about my son. I was
Wait.
in shock. I was.
Did she say she was? Did she even name Jorge
No,
at all?
no, no.
I was just worried about her son and her dogs. I mean, come on.
Yeah,
Don't
she
worry
has
about
that soft,
sauce.
innocent
I know,
voice she didn't have on the video. Yeah. Yep.
Traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge. Move to strike. This is outside their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
No, her son was at school, and that's why Brian called her in the morning, because it was her day. She's the one supposed to pick him up, and he knew he had to call her because she was probably either drunk or hungover. So that's why he contacted her in the morning. So
You know, if it's that bad, why is he even dealing with this woman, especially with his kid? I would never want my.
I can tell you why. That room they are in right now, family court will give kids to the worst people in
I
the
know.
world.
It's terrible.
And if he didn't check up on it and she went back to court and said, he didn't have his son last Thursday, they would say, oh, you broke your custody agreement, pay.
Yeah, exactly. I mean, yeah, he was paying her, so even though, I don't know.
Yeah.
It's fine. I mean, I get it. I know that they do this stuff, but like, especially her history with the DV and the drinking in excess. So,
Yeah, and I just refer to the police interview. I can't drink, I won't drink, I don't.
yeah, she claimed she wasn't even close to being drunk the night that all
Yeah,
this
they
happened.
had 2 bottles of wine. It was a good day, Jamie.
Mm-hmm.
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation was the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the
Are
day
you-
before the interrogation.
I understand that.
We're not talking about an intoxication.
But are you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February?
Well, the one was from the night before, around midnight the day before. So they could have drank that and gone to bed.
25. Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes. It wasn't raised in any of the 3 motions that have been filed.
Judge, I didn't ask her that. She volunteered
I
that.
understand it. Objection sustained and it's stricken.
You said she should do that.
Did you speak to the deputy about what had happened?
Yes,
Okay. And then were you asked to stay on scene?
by both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
Whoever said something about her hairline this morning, yes. This looks weird. Did she shave it down? It looks like she has shaved this off and then her hair is around it.
It looks
Did,
pretty
Pen-
normal.
did Pena go a little hard on her, bounce her head off a toilet or something? It looks weird.
Oh, she has it slicked back, so
No, but this you can see it's kind of like the wave from it's slicked back around here and then it's just flat in that spot. Looks weird, Jamie. Looks weird.
okay.
Exactly. That was presented to be snuck in.
It's my understanding, yes.
No foundation to her.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? What, was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hopesall asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Hopesall.
How did you unlock it?
She handed it to me and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay.
00.
And when you unlocked it, did you give it back to the detective?
I did.
Did you ever see the phone again?
I did not.
After that incident, was the next time you were spoken to by Detective Copesel was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to the videos that you recorded on your phone from the night before?
Jamie, do you know what this is?
What?
The thing I brought up on the screen.
What about it?
This is what's called grifting.
Oh my gosh, you
Good job,
guys.
Dave.
There's a class called
He's an expert.
Basic Grifting. Should we all learn how to be grifters together?
Dave, well played.
Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes.
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
How much did you straddle?
At some point, did they all leave?
Yes.
And at some point, did they tell you they were finished with the work there at the scene?
Yes.
Okay.
No, I didn't run out of grifter shirts. I just put on another one you can buy at my spring t-shirt store. My cream pie.
What did you do?
I went inside my apartment and gathered a few things, and then I went to.
Everyone should go follow MG Law. Can one of the girls share MG's link? 1,800 away from 10K. And he do the late night shows. So if you are in insomniac or are working nights, you better sign up for MG Law. It's good, clean family fun until Brandon gets to him. Then it's really fun.
Husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son.
Amy, these are the people you attract to us now.
Me?
Yeah.
Me? Little old me.
Yeah.
Please.
I redecorated Sassy Pants. I have it like this for a week now.
And with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Copesel?
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized?
Correct.
And you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Copesel told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Copesel's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
How old is her kid now? He must be in his just slight pre-teen or maybe a teen now.
How old was he
It's-
then? I mean, is he like 11 now or something?
Yeah, he was in school back then, so and 4 more years. So 11, 12 years old, maybe.
Yeah. Maybe. Yeah, I don't know.
Yeah, she was so confused and hungover about what had happened that day, but she clearly remembers all of her conversations with that officer.
Oh yeah.
Yeah.
She's sitting there going, I was so hungover, I didn't even know like what was going on. I was so confused. But yeah, she details everything.
Yeah. roughly 13, 14. So just beginning in his teenage years. Imagine going to school with this mom.
Mm-hmm.
All right. Can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding the case for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this time.
Okay. You were concerned about the case and you wanted to call her.
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her, in all honesty, that I felt that she was trying to trick me.
Sustained.
She's allowed to trick you. She's a police officer looking for the truth. No, she's not. She just wants someone to blame it on. She must. She is allowed to trick you.
Did you have a conversation about your phone?
Yes. I asked her.
Answered.
Overruled. You may answer the question, ma'am.
So did you call for a yes or no? She said yes, and now I don't know like what's pending and how to object.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and asked me if I remembered about when I was being pregnant, and it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion about you being interrogated at the sheriff's department?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Kopsel was pregnant and not feeling well?
Correct.
So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I...
Well, they have a record of the phone call, but the officer didn't remember what was said on it, and she didn't remember saying, "I will be there." So it's he said, she said.
I was supposed to be picking my phone up.
And remember, she was drunk, hungover. The officer was pregnant. Nope, I'm not going to say anything. But if Zach was here, he would say kind of the same thing.
Over at a particular window, and he says, "No, your phone is upstairs, so we would just like you to come upstairs, and that's where you can pick up your phone."
All right. And so did he escort you upstairs?
He did.
How did y'all get upstairs?
In an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants.
His firearm was on his waist?
The entire time, yes.
Okay. So y'all got off the elevator. Where did you go from there?
He brought me into a very small room, and they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else prior to that time. Was there any discussion that you made outside, any discussion between you and either detective?
Well, other than being fabulous, she's up to no good. And her lawyer is an absolute pillar.
About anything, the phone, questioning, anything before walking into that room?
Titty whites.
Okay. So directly off the elevator and walked into the interrogation room? And then we've got the video on that. Now, you and I have watched the video, correct? And you've seen the motion where I've referred to the questioning, where she asked you to sit down.
Yes.
You recall that happening?
Yes.
Did that refresh your memory watching the video?
Yes.
Do you recall her saying that she had received the autopsy?
Yes.
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
Yes.
This was prior to you being read your Miranda rights.
Correct.
She also said, we're not done talking about the incident. You recall that?
Yes.
And then she said, we just have to do it.
Yes.
How did that make you feel?
Sustained.
How did it make you feel?
Were you trying to comply with the officer's demands?
My God.
Overruled.
In every way.
Were you trying to
In
cooperate?
every way.
Were you polite with them?
In every way.
I can't wait for cross.
And when she said that, we just have to do it, you said, just like we did yesterday. And then you said normal protocol.
Yes.
Is that what she had said the day before?
What do you mean?
Normal protocol.
Yes.
Had she said the same word? Could you said normal protocol to her?
I was reiterating to her what she had said to me the day before.
What?
I reiterated to her what she had said to me the day before.
So she read the Miranda rights to you,
Except number 9.
except number 9. She read the rights and then she
knows. Except number 9.
Honey boo boo, you know I love you. But just because you found a piece of paper where it's on and you think that's important for Miranda rights to, it's the same thing. Even if you get your phone back, you can't delete the videos. They have the videos. So, honey boo boo, you and I are gonna be just fine when I come to see you. But I know I'm gonna see you in a very cold room with bars on the windows because you're not that smart. And that's why I have a chance, because she's stupid. I haven't heard anything so far.
said, do you understand what I've just read to you? And you agreed that you had.
Yes.
But you were not read having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you. Do you agree to speak to us now?
I was never asked that.
But you choose to answer. When you choose to answer, you waived your rights to remain silent, because remaining silent is this.
Gotcha. Good job.
Thank you.
Was that hard for you? Because I feel like that was very hard for you.
It's sitting still and looking at the same spot and trying to keep my breath. That's becomes a lot of things, and I don't multitask. I often fall over when I try to walk and chew gum at the same time.
Mm-hmm.
Yes, she
The way
wanted her
that she acted, the things that she said, the fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Sustained.
She was in custody?
Yeah, it's been conceded by the state in their response that it was a custodial interrogation.
Okay, but she wasn't aware of it. She wasn't aware she was in custody.
What is her subjective perception?
Thank you, Brandy, for showing up we have had so many people asking how you're doing, if you're okay. I've been telling everyone to go check out your new podcast episode. And yes, Brandy is doing well. I hope you're doing excellent. But thank you so much. People have been a little bit worried about you. They should follow
Hi,
you on
Brandy.
TwitTwat.
Yeah.
And I hope everything's great in Florida and you're ready for Boone o'clock next week. It's going to be lit, as the kids say.
Yes.
Matter.
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed small space. She was.
That all goes to whether or not.
She was being questioned by.
No, you didn't just hush the judge one more time. Let me finish. Oh, you'll be in the courtroom for Boone? I will be shipping you links. Because I want to know how she smells, if she's just as beautiful in real life as she is on camera. Can you see she had clipped her pants in so they are fitting her better? I want all the dirty deeds. Maybe slip her a note saying, Baker got a Dr. Pepper with your name on it, honey bunny.
Brandy, don't do
Boone,
any of
Boone.
those things. Don't you dare. And when you say,
Two
what
lead
is,
detectives,
like, how does she
homicide detectives.
smell?
One of them was
Ugh.
wearing a firearm.
Everyone wanted to know how
she was trying to cooperate as best she
that was
could.
okay.
I think her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation. That I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not, based on
subjectivity matter.
Excuse me, based on
subjectivity matter under the case law.
Based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's relevant.
Objection's overruled. I'm sorry, the objection sustained. I apologize.
Did you understand you were not going to get your phone back until you answered their questions?
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Sustained.
It doesn't matter. Doesn't matter.
Ma'am, that day, you came to the sheriff's department to get your phone?
Yes.
Did you know that you were going to be placed in custody?
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
Doesn't matter.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Overruled.
Were you there answering the questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
Let's get to it.
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay.
Oh my
And
God.
that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct? And you consumed no alcohol in your home that morning, correct? So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
Now or then?
Then.
Did alcohol affect my conversation with her?
There's a jury instruction that says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect my answer?
Judge, I don't think she understands.
I don't.
Hey, she understands everything. She excels at everything. She was a straight A student. Don't you throw shades at my Boone's name.
Okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she didn't know what. She said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I don't know.
She said she didn't know
What are the legal grounds of your objection?
That's a speaking objection again. You.
All right, you may proceed.
All right. And you understand that you're charged with second-degree.
No legal. What's the legal ground? I withdraw.
I withdraw. I don't know.
At this moment, Sarah knew she effed up.
Well,
Murder in this case, correct? You're facing a potential penalty of life in prison, correct? Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
I would object to that. I'm not understanding what the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Copesel's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
Response.
Judge, I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 years on the low end. I agree with all that.
She was here yesterday. No, this morning. Yesterday or this morning. Yes. And she have reached out to Cop Daddy, so we might get an interview at some point. I'll probably record that because you ladies can't be around Cop Daddy. It'll probably be nothing but $1 super chat saying, "Get that clothes off."
We just got through at the jail.
Can't have none of that.
Meeting the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, then he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination.
So was Lucifer.
She said there versus what she's saying
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time.
Give me cottage cheese, alky legs, or give me death. Agreed.
Time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted?
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to counsel's table. While she's in the process of returning to counsel's table, anything else further from an evidence or testimony perspective from your side of the ledger?
Yes.
Okay. Anything else from the state other than argument?
Just argument.
Okay. All right. Once Ms. Boone's seated, we can proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided. Mr. Owens, it's your motion, sir. You may proceed.
This better be good. It won't be, but it better be.
Mm-hmm.
They ended for the day. The judge had to start another trial this afternoon. That's why she was so angry. It'll pick up again next Wednesday, probably. But Boone will also be going there, so I'll figure something out. We might do it on a Saturday, just because it can't be that long. And let me just dispel a very nasty rumor that has snuck into chat. It's not every day she says no to a shower. She does shower, but she's very environmentally correct, so she doesn't use unnecessary water. And again, La Lala's the tuna is a bit better with some flavor. So,
Oh my God, no.
It's my understanding of the law
You stop it.
regarding Miranda.
God.
First issue is, was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed.
Happy New Year, Laura. What? I don't know. What?
Stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances.
Moist o'clock. You're welcome, Jamie. Thank you, Iris.
Iris, why don't you come through the garage? I need to speak to you about something.
Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions
and
they can later use at trial to impeach the defendant and convict him.
Sure.
The law allows law enforcement at that stage to use deception, to lie, to trick
She always wanted an attorney, but this guy apparently is the only guy who's willing to go along with her insanity. Remember, it was the court who forced her to go pro se.
We found the murder weapon. It's got your DNA on it.
They're allowed to
Your
say
co-defendant has come in here and confessed and implicated you.
They're allowed to say it.
All those techniques, when it's really
10-20.
deception,
But I have
they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick. That right is fundamental. You cannot be compelled to incriminate yourself. You cannot be forced to talk.
But she's not forced to incriminate herself before Miranda is read. She said, we got the autopsy. We have to take a talk about that. So I'm just going to read you your rights. It's
got to be free will and a choice.
And it was. She could shut up.
And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens,
but it didn't.
We've got to punish law enforcement to correct that type of misuse behavior. It's illegal. So you got Detective Kopsel on the one hand.
Yeah, if that was what was done, but that's not what was done.
I got to read your rights. And you have a right to remain silent. But within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that should be allowed or is allowed. There's nowhere in the law that should be allowed. It's actually illegal to tell a suspect, we have to talk to you. We just have to, before reading Miranda rights.
But we have to talk to you, so I'm going to read you Miranda rights. How else should they put her in the room and read her Miranda rights before saying anything? Jess, why aren't you here to yell at him? Because I'm getting tired of yelling.
That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened. But that's the implication this detective gave Sarah Boone.
No.
It taints the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
But the statement of we have to read you the rights was made before we have to talk to you. So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterback.
No one is having a confusion except you.
But Sarah Boone was brought up there under false pretenses.
Nope.
A traumatic event. She lost her boyfriend. I'm coming to get my phone. I've been tricked into coming up here to get my phone.
Well, according to her,
and I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you. We just need to do it. And then she reads the rights.
Sarah should know better.
Right
She's
there within a few seconds of each other.
Yeah, it's not her first rodeo.
It's not her first rodeo.
That's improper. It's illegal. It's coercive. it forces this not to be a valid.
And Peter isn't in chat, but he just wanted to inform me. Pointing would also consider being communicating or speaking. So you couldn't even do that. So how the hell are you ever to get to talk to any suspect?
Valid waiver of her rights under that circumstance, coupled with the fact that she came down under false pretenses.
But it doesn't. This is the same argument as saying anyone answering an advert for free rocks being arrested and interrogated, not arrested, but being interrogated when they show up to the free rocks. Yes, they were coerced, but again, it's to break the law. You can do that. It's how can he? I'm starting to feel like you when we have our after stream meetings where you just yell for an hour.
Me? Oh man.
Coupled with the fact she doesn't have the 9th question,
which isn't required.
If you think about it, okay, you got a right to remain silent, you got a right to a lawyer, those 3 or 4 questions, and then, do you understand what I've just read to you? I'm paraphrasing.
You don't even know the question.
But then Detective Kopsel goes right into questioning. Once Sarah says, yes, I understand, it's an acquiesce to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us? That is
it's an implied
the time of free choice. That is the time of decision for Sarah.
No, because that's the second question. You have the right to remain silent. No, third question. So she's already been told she can shut the F up. She says, I understood those rights as you read them to me. By opening her trap and just start moving it. If the judge come back with any other ruling that then I am going to do Beauty on a Budget next week.
Okay.
Or else Jamie will be doing it at noon at every lunch break next week. Kathy, that prosecutor comment about mimosas was good. Talk about it, Dick. You all know she's not trendy and hip like that. More like beer and vodka in a trailer park. No offense to trailer parks. Lived in one myself early on. No offense to beer or vodka. I partook in 1 or 2 of those. But no, she probably didn't have a lot of mimosas that day. And who wants mimosas?
And what do you call them? Mimosas?
Yeah, what else is it?
You don't continue.
M-I-M-O. Mimo. S-A. Sa. Mimosa.
Hang on. Gotta step out a minute.
Jamie. I don't know why Jamie is always after me. But I said it as I pronounce things as they're written. But thank you, Kathy.
To be given that opportunity. But the way I understand, Detective Kopsel had the autopsy. She had the blunt force trauma. Those were not questioned. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before. So sure, any detective...
No, 2 bottles of wine, 3 within a day is what they had on the receipts.
Worth their salt would want a statement. She'd already said we had probable cause. We'd already made our mind up that we were going to arrest her. if she didn't come, they were going to go get her. If she came and said, I want to invoke my rights, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them that she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Wine in a box.
Any response?
Judge, the United States Supreme Court has said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th. They are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Kopsel's testimony, the state would argue for the...
Sarah should have had White Claw. Makes you invisible to law enforcement because ain't no law when you're on the claw. Thank you, Marissa.
The reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Kopsel's. And of course, she has a bias and interest in the outcome of the case, whereas Detective Kopsel has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you for the reasons that we stated in our multiple responses to their multiple amended motions to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
No, Judge.
All right. Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed, but I'll be here working.
Judge, for the record, those 2 exhibits that I tried to introduce, they will be admitted
Correct.
to the record?
Yes, of course. They were pre-marked. Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. State, what, if any, positions do you have with regard to the restraints?
Again, we've already decided that issue. I don't know that there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already. And unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Response.
Can we please call her Attorney Boone? Yeah, we could do that.
Just one clarification, but you know, she's here today and she's in handcuffs, so she has difficulty writing. She has.
Let me just interject for 1 second. She will be hands-free.
Okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature. She has a fundamental right to a fair trial. She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger. And
they already had this motion back when she was doing it herself. She can carry a taser. And there is a piece of cloth in front of the table. Have she forgotten already?
Automatically will take that to heart, and it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table. I don't know if we switch it. Does the prosecutor go over here?
That's your table, sir.
That's my table. Closest to the jury. So she'll be sitting here with the other 2 lawyers and I. And The only time they're going to see her walk in and out is she's always going to be in the courtroom.
They're never going to see her walk in and out.
So the only time is when she testifies. So I guess I don't know if you have leg restraints that she can wear and walk, but we believe.
Can I tell you something, Mr. Attorney? Normally, when they do that, I've only been doing this for a year and a half. I am not a practiced attorney like you with 100 cases. If they're going to testify with leg irons, they will be placed in the jury box before in the witness box before the jury enters. Ain't no thing. We've done it before. We can do it again.
Believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny. She's walking from the defense table to the witness stand to testify on her own behalf. But I don't think it's necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and I assume the tables are going to stay here.
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. You know, there are times when criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative, and she understands the importance of behaving, and I have every intent that she will comply.
But if she has leg irons on, she can't get away from me. I'm a smart lover.
Comply with the court's directive, and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Anything further as to that issue?
I don't believe that's case law authority on the issue.
Okay.
Police.
All right, thank you very much. With regard to your request for clothing in that, you can certainly go to the jail and provide, have whoever it is that you want to meet with her in the meeting area to get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. Okay. So your motion will be granted with regard to the clothing. You'll have to address with the jail, having a person come in there to take her measurements. They may have to be with you, counselor, in order to facilitate that. But the clothing will have to be dropped off at the jail, and it will be transported with her in the morning each day of trial. Okay. With regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair, cosmetics, civilian clothing without restraints for trial. Just the arguments in there.
And the Estelle case that you cited spoke to being dressed out in a prison garb. Doesn't really address a prison guard in shackles. It doesn't address any beautification or anything along those lines.
I just think it's just part of a fair trial.
The other problem is it's contraband. That stuff's not even purchasable at the commissary at the jail, any makeup or anything along those lines.
Well, I'm going to have the two paralegals here. I say the paralegals. One's a lawyer now, and the other is a consultant, but they're females, and they can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any. You
can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
Can she be allowed? Can the two females on the team, can they be allowed to apply some type of makeup to Ms. Boone?
State?
We don't have any dog in this fight. I've never heard of it happening. That doesn't mean it's not permissible, but
if you want to try to do it here in the courtroom, that's fine. But be advised that when we start court, we start court. So, and I intend on starting it at 9 o'clock every morning. So I'll have pleas every morning and other matters because the court still has other business at 8:45, and I plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter. So your motion will be granted with regard to the clothing. You can perhaps someone attend, travel to the jail with you, sir, Mr. Owens, to take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secured areas. But if you want to attempt to have members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request to removal of the leg restraints, but the hand restraints will be removed. I think that it falls under the same analysis.
It needs to be done in the courtroom.
Yes, sir. And then the last item teed up for today is the, I'm sorry. Yes. Yes.
Yes, Sarah has been following Boone and a budget religiously, and is it confirmed or unconfirmed that the reason?
So corrections in the Orange County.
Is it confirmed that Brandy will be going there to apply verdict brows? It's an unconfirmed rumor, but it could be true. That's why Brandy has been hired for when the verdict comes in to fix her brows. You know, no one has verdict brows like Brandy.
The sheriff's office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband. They don't know what's placed on her person. That's the concern.
It's just going to be some facial makeup.
I understand, but
I don't see
DOC and sheriff's office are telling me they can't do it because of the concerns that were just outlined after she's returned to the Orange County Jail facility.
Okay.
All right. You'll get an order with regard to the restraints no later than tomorrow. Moving now to the state's request for protective order. I've reviewed that. I need to understand what you're looking at, Mr. Owens, with regard to these custodians and supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
Yes, my JA had emailed all y'all, I think last week after it was filed, that said this would be added to the hearing for, I guess that was filed on Monday, forgive me. I had emailed y'all and said that it would be addressed today.
Every one of you 13th, please remember Brandy. If whenever she live streams, just remember she is on brow duty for Boone. BDB.
That was relating to me subpoenaing the enlisting the I think it was
it's the third amended witness list lists certain people as witnesses: custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor for the Office of the State Attorney, and misdemeanor supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's work product or opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
Judge, as you know, we have filed our notice of intent for battered spouse syndrome in conjunction with self-defense. And we have listed and plan to introduce the fact that George Torres had been arrested, I think, 3 or 4 times prior to this event.
But
and I
so
think on
had
3
she.
of those cases, the case was dismissed against Mr. Torres. And it's going to come out that Sarah Boone had requested the charges to be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of bail and then get the charges dismissed as a battered spouse. That's a common theme. So ultimately, the jury is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their request, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons?
That.
How would that not be protected by work product?
Well,
As to whether or not it was
if it comes out, if it comes out that she went down there and requested the charges to be dropped and they were dropped, then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charge to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't have to drop cases, even if a victim claims they do. So just that decision by the state attorney to drop it was their decision. They considered the victims, but it was their decision to drop it and their power and authority to do so, not the victim's authority.
Okay.
But she didn't cooperate. So
Response.
Judge, that's opinion work product. That is absolutely protected. I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we are moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And if they want to get...
Jess is constantly monitoring if anything comes out.
Public records about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. I mean, the state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that they don't even have this evidence. We got dropped last Friday, but the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone.
Oh.
So all that evidence is going to come in, but
I'm going to love this case.
Coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I have no. That's why I have Jess.
I did not make the argument that the state attorney was going to be called to ask why they dropped it, as he just referred to, where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in the case. Not why we chose to drop 3 cases against George Torres, but they have the ultimate authority. The victim does not control the case. The state attorney does.
You have a written order on the motion, protective order for tomorrow, by tomorrow as well. Anything else, state, we need to address?
It appears, and again, been conducting motions all afternoon, it appears that we are set to allow the defense.
You missed actually a fun little 3-hour romp into the world of Sarah Boone. That was it's actually as stupid as you think. This lawyer could actually be worse than if she had been pro se.
To depose our battered spouse syndrome expert at 10 a.m. tomorrow. Yeah. And that will be done virtually.
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
That's set at 3 p.m.
Okay, that's still set at 3 p.m.
Yes. There will likely be a pending motion to strike if his testimony is duplicative with Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here or is that taking place in South Florida? Virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
Okay. All right.
Judge, and then on Dr. Brannon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10. Y'all's expert by Zoom. And we did talk about that at the jail, trying to schedule something for tomorrow. So she just evaluated Sarah Boone from noon to 2, and then I'm going to take her deposition at 10 tomorrow morning by Zoom. And then we're taking Dr. Brannon's deposition. If they file some type of motion about that, then of course I'm going to respond. We're going to need to have a hearing on that. So.
Okay. Go ahead, I'm sorry.
Those 2 things are the only 2 things that I believe we have left prior to jury selection on Monday.
Okay. If any motions are filed by anyone moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, State, if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the potential penalties, everybody's on the same page as to what those are. Okay?
Yes. And if y'all could send me that, I'll go out to the jail. I'm going to be here.
If you could favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance.
Yes, and we're going to be filing a motion in limine to exclude the battered spouse syndrome testimony that will need to be addressed. Just waiting to see now how the depositions pan out tomorrow. But based on what we witnessed this afternoon, it's the state's position that we're going to need to file a motion in limine.
Okay. All right. Appreciate it. All right. Thank you all very much. We'll address scheduling of any motions on Monday. And it may be a circumstance where, as the court had identified earlier, that we're just going to be looking at cause issues and what people may know about this case. That'll be happening before we turn it over to you all. Which would include, Mr. Owens, your opportunity to voir dire on any defenses that may be being raised in this case. So it may be we may get a panel and then ask them to come back later in the week so that we can have those motions after we get that panel of 50, once we deal with all the cause challenges. Okay? All right. Thank you all very much. We'll see you Monday morning at 9 a.m. Court's in recess. Thank you.
Definitely needs a tiara. Kathy, you are right. Because she is a special little princess. Was that Rose Hashinia something someone said this morning? Then happy birthday. Whatever it is. I don't know. What about leg irons and makeup? Leg irons will stay on. Makeup, she was allowed to begin with, and then it was removed because the prison don't want her, because they were afraid someone could hide contraband in the makeup that they can't check. I don't know. Can you put drugs in the makeups, maybe? Nothing was granted so far, but apparently by end of business today, which should be soon, he would have written motions. I'm pretty sure as soon as there's anything dropped in the case, Jess will upload it on the Discord so you can all see it, because it's 11 o'clock my time, and I'm probably going to go to bed before everything happens. It's not embarrassing, getting pampered a little bit. She might call you Big Daddy Baker. She might. And I might call her Alky Leg. Alky Leg. I think she would like me calling her Alky Leg. It's New Year's. Happy New Year! A New Year in Israel. Well, I've never been that far east. No, I've never been that far east. I only moved west. Yes, they are quite creative when it comes to doing that. Jess has just confirmed she will upload it to the Twitch Discord. It's the year 5784. Well, good on you, planet, going around the sun so many times. I don't really have anywhere to send anyone. No one's streaming. Everyone's. I think a lot of courts are. A lot of the courts are closed. The only one I can see is Aussie Insider, but she doesn't allow people to redirect to her. You can go watch a guy talk about United. I wouldn't put that on you. No, really nothing. I don't know why Aussie haven't opened up for redirections. Anywhere else fun? Nope. 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 I don't know any of these people. See you somewhere down the road. I don't know. What's this? Yeah, I'll send you over here. It's nothing, but if you want to hang out, you can watch that. It doesn't show up. Of course it doesn't. Well, go enjoy the rest of your day because I can't get anywhere with this. So, thank you all so much for stopping by. Thank you all so much for the super chats, memberships, likes, subscriptions, blah, 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 blah. All the YouTube things. Love y'all. Jamie, she doesn't love you just as much as I do, but she cares for you.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100. Because it is 100% correct.
So you literally built a cannon?
Yeah, it's pretty awesome.
All right, I'm in love. Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't have cared.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.
So there.
Everybody has.